For I have long wished for the proper occasion to have Mr. Marshall's gratuitous opinion in Marbury v. Madison brought before the public and denounced as not law.
Well, I was wondering when you would get to Marbury v. Madison. Well, let us get to it. You argue that William Marbury and his associates, the fellow applicants, did not have the right to the commissions that they demanded.
Right. When you, in your rush to fill all of the appointments made in the final moments of John Adams' presidency, left a few undelivered, they were left incomplete. If there's any principle in law that has not yet been contradicted, it is that delivery is one of the essentials to validity of the deed.
Your idea is founded on the supposition that the commission is not merely evidence of the appointment, but is in itself the actual appointment, a supposition by no means unquestionable.
Could anything exceed this perversion of the law?
The law creating the offices gave the officers a right to hold those offices for 5 years independent of the executive. The appointments were not revocable, but vested in the officers' legal rights, which are protected by the laws of his country. In denying them their appointments, you, sir, broke the law.
So you've said your subjectively narrow reading of the law in this case serves the political and perhaps personal agendas of both you and the former president.
No such thing was done by myself or President Adams.
The events say otherwise.
Well, wait a minute, Mr. Marshall. You were the Secretary of State.
I was
at the time.
That is incorrect. Yes.
And you were charged not only with signing the writ, but serving it.
That is correct.
So what happened?
Well, during the last month in office, the very last month that he was president, John Adams submitted 217 nominations to the Senate in 1 month, at an average of more than 7 per day.
We were very industrious, weren't we?
Mm-hmm. I think ambitious is the word that you are seeking.
No, I sought industry. It's you who seek ambition.
Most of the positions that had been created by the laws passed the very same month that they filled those positions.
But they were long overdue.
Long overdue. And you played a key role, as our illustrious moderator has informed us, in making those laws a reality.
I concurred with President Adams when he said that it was a burden upon him nominating these positions, and that burden was so heavy upon him.
It must have been grueling.
Oh, it was. I mean, as Secretary of State, I was responsible for, the President relied upon me to connect with these job seekers. Their patrons flooded me with letters. My hands were full, writing to nominees, preparing and submitting the actual nominations, formalizing the appointments and official commissions, and of course, yes, having the commissions delivered.
Not to mention the fact that, as has been pointed out, you were simultaneously the new Chief Justice.
Yeah, exactly. You understand. I mean, I really had my hands full. The double duty added to the encumbrance.
Well, it was not ethical, though, I think is what we're getting at here. If I read your mind correctly, sir, and your statements correctly, Mr. Moderator, your dual role as Secretary of State and Chief Justice made a mockery of the balance of powers between the executive and judicial branches.
We did nothing that was illegal or unconstitutional.
I did not say illegal or unconstitutional. I said unethical.
Actually, I believe the word you used was ethical.